My Lord, can I pick up three short points from this morning? First of all, but not one of the points, is I was asked questions about modification of the MPA to allow the fishing that was in place beforehand. Would that be an acceptable result? And the answer is yes, of course, on the basis that the modification is suitable. We don't want it to be suggested, for example, that there can be one fishing boat every 3 years or whatever. So it's the recognition of the pre-existing fishing position for Mauritian flagged vessels, whether or not crewed with Chagosian fishermen. The 3 points, the first two are to deal with Ground A. I should have pointed out but failed to clarify in our printed case, when we're dealing with the history of fishing and meetings, you'll see on page 152, above paragraph 31 of our printed case, meetings between the Mauritian and UK Prime Ministers. And that led to correspondence. The complaint is that this material was well known to Mr. Roberts and Miss Yaden, but did not feature in the evidence below or in the consultation. In paragraph 35, you'll see that there's a letter as recently as December 2007, which mirrored, as it says, the record in the Mauritian Cabinet paper. And you'll see there are two parts to this relevant to our case. One is the reference to sovereignty in the first 4 lines. And then secondly, over the page, during the meeting, I also raised, and we have emphasised also, I also raised with you the question of our fishing rights in the waters of the Chagos Archipelago. Mauritius has historically exercised such rights. What I didn't point out is that when this document was produced in the litigation so far, the first 4 lines were redacted. So there was no distinction between sovereignty and fishing. It didn't become clear until the redaction was lifted. And this is explained in paragraph 37, and also how close it was to Mr. Roberts' testimony. So in answer to an earlier question, yes, we do join issue with Mr. Roberts' testimony, and this is an example of why we say there is cause for doubt. The second point I mentioned this morning, but I couldn't put my finger on it, is Mr. Dunn had put in a consultation response when he was dealing with the paucity of the material. And it's in his first witness statement, volume 2, page 590. And you will see, if I can find it, this is, it should go back to 586 where it starts. 586 is the public consultation on whether to establish the MPA, and then paragraph 31. Various points being made by Mr. Dunn. And then when you get to page 590, he is talking about the impact of the non-disclosure.
Yes.
The impact of this non-disclosure is illustrated by my own, jointly with Professor Brown, written submission to the consultation, which isn't before your lordships and my lady in the appeal. It was before the divisional court. Despite taking great care to consider all relevant issues, we were unaware at the time of the nature and extent of the undertakings and obligations with respect to Mauritian rights in buyout waters. However, we had commented that in respect of the environmental impact assessment deficiencies, which he then sets out, and as to the joint communique, which you have been referred to already, issues of Mauritian claims to sovereignty are barely alluded to in the CD, which is the consultation document. And you will see as you run through it that this is then a series of questions. What does this mean? What are these issues? What are the limitations? What has happened? Furthermore, the public consultation does not indicate the disagreements that have subsequently arisen, which therefore leave the joint communiqué as a misleading statement of Mauritian intent. And that goes back to the end, paragraph 45. We consider the public consultation exercise to have been poorly prepared and to lack essential information. So it was a point that was being made at some time ago.
Do we have that document somewhere?
We don't, well, we may do, my lord.
We've got a great list of the responses, but they're summarised and the writers are deleted, aren't they?
I think so, my lord, yes.
But so we don't have particular.
I can produce it, but the summary seems to make the point I wanted to make. It was before the divisional court and will be in court somewhere because I have my divisional court file, so I'll see if I can find it and produce a copy. Well, the third point was to deal with my answer to Lord Sumption on the cable and paragraph 7 as to whether that was the highlight of our case on that document. Well, it is, of course it is. It's the highlight in terms of speech. We also rely on the summary in paragraph 1 and the summary in paragraph 15, particularly the summary in paragraph 1. Why would there be an incorrect summary by this note taker? He said that the Biot's former inhabitants would find it difficult, if not impossible, to pursue their claim for settlement if the entire archipelago were a marine reserve. And then
is this a Guardian summary?
No, my lord. The Guardian summary
an original summary
is just in that vertical.
Yeah, I see.
Isn't this the writer's summary of, for example, paragraph 7?
It is, but there may well have been more because this is a summary. It isn't a verbatim word for word.
No, but it is supposed to summarise what follows, isn't it?
Yes, and you see it.
And therefore, one really looks at paragraph 7 to see what he thinks was said.
Well, my lord, we rely on 1, 7 and 15, but in those three, where there's direct speech, that is, of course, the highlight. But we also see it as not the highlight of the document, but not the highlight necessarily of the case, because this would have been, following the order of Lord Justice Stanley Burnton, the opportunity to cross-examine, question Mr. Roberts and Mr. Yaden on this document, based on the basis that it's a true document, to see what we got out of him and Miss Yaden on the purpose generally, because I think I told you that we only got as far as paragraph 2. Yes, the order of Lord Justice Stanley Burnton is at page 420 of the same volume, I think.
I mean, your cross-examination is going to be rather limited because asking person A why document B, which they had nothing to do with, says this, is asking an impossible question, isn't it?
My lord, of course, it's the starting point for other questions, but many of the questions would have been to determine the reliability of the document.
I mean, ultimately, the point is your second point. You'd be saying, well, why shouldn't we put more weight on this document than on your unsupported testimony?
That's right. Yeah, that's
the substantive point.
Yes, yeah. It's the main point is this is a contemporaneous record. You didn't take any notes. You come along years later, give a different account. Why should the court not rely on the contemporaneous account?
Well, one problem about the document is that clearly the British side in these discussions and the American side were interested in different things. The British side, at least ostensibly, were interested in the ecological or environmental considerations, or at least, as you would put it, claimed to be. The American side were basically only interested in the implications for their base, so one would expect them to give prominence to the consequences that this proposal would have for the future of their base. I mean, the whole emphasis of the document is likely to be different depending on whose side is recording it.
My lord, if we had heard from Mr. Roberts that all of what's in that document is true, but I was telling a particular line to the US for a particular reason, that would be one.
That's not the suggestion I was making. But you would expect the Americans present to pick up those aspects which had significance for their own priorities, which were concerned with the base, and to give them particular prominence. It's nothing to do with the impression that the British side was trying to create, but simply this is a document that reflects what the Americans thought mattered to them for reasons which were not necessarily the same as those of the British, although they might have been.
Well, I don't think I'm disagreeing with you by saying that it still requires explanation and balancing as to what is said, because the point that we've been making throughout is when one judges the evidence that was being given by Mr. Roberts and Miss Yaden, which is set out in the divisional court, there was no balancing exercise because the cable was not admitted. Lord, it isn't the way I described it. It was, I think, described by the judges in the divisional court that this was referred to as the golden bullet, which is certainly what we would have said it is. But also when it came to the admissibility ruling, the phrase you'll see in the appendix and in our case is "my bat was broken" as a result of the ruling. So it wasn't considered by the divisional court to be some small inconvenience. It was clearly central to our case and so considered. Lord, I know I've got a few minutes left rather than hours, and there are some important issues of general applications I still have to touch on. One is the correct legal test. This is the would-could debate. Before I forget, could I just give you the judgment of Lord Justice Stanley Burnton when he deals with the interests of justice as to why this cross-examination should take place at all on the basis of the cable. It's at volume 2, page 360, at paragraphs 28, and it's recorded in paragraph 23 of the divisional court. Lord, the correct legal test. The respondent in his case, at paragraph 76, refers to CPR 5221, which used to be, and was at the time, CPR 52.11, including that an appeal will be allowed where the decision of the lower court was unjust because of a serious procedural irregularity. So we start from the same position. It is then accepted in his case at paragraph 77 that those provisions should be applied with, quote, a degree of flexibility, and, quote, to do justice in the particular case. So we start off with the same principles, but the respondent then seeks to distinguish the factual context of the cases upon which we rely in paragraph 78 to 83 of our case. And what we submit in broad response to the approach of the Secretary of State is the respondent has failed to consider the central questions which are at the heart of this part of the case. What test should be used to assess whether there has been a serious procedural irregularity on the facts of this case, on a case such as this? What is necessary so as to do justice? And we say the could standard should apply to the makes no difference test. The decision of the Court of Appeal is a would approach. And we say that the respondent fails to address this matter of principle at all. So what you find as you go through the respondent's case is that there is a summary of what is said by the Court of Appeal, this paragraph 84 to 91, and then the Court of Appeal was correct. So again, no analysis of principle. Could I just in a few minutes refer to our own authorities? It's suggested that our authorities are all administrative authorities. They're not. What we're dealing with is examples of cases across a broad range where the courts have had to consider whether or not there should be an interference by the appellate court, either with the administrative decision or with the lower court. And amongst the cases, and we've given you several, could I mention one which does require a new authority? It's in our case at paragraph 78. It's in our case, not an administrative court case. I'm trying to shortcut, and it's not helpful. So, could I just put this in context, otherwise I'll just miss out chunks. In our printed case at paragraph 79, we set out the relevant paragraph from the Court of Appeals judgment, 89 and 93, where you have the Wood approach being applied. Then we start with the standard of makes no difference, and we refer to cases which begin at paragraph 75. And I wasn't going to take you to any of them in detail. These are all John against Rees type cases, and ex parte Cotton, with whom you will be very familiar. Could I correct a reference? Ex parte Cotton is in our paragraph D on page 170. It looks as if the numbering has gone awry. 65 refers to 3628. I think it should be an earlier page, but you'll find it in the same bundle. Lloyd against McMahon, you will again be well aware of. The reference should be at 669, not 675.
Can I ask, you've cited a large number of cases which are quite familiar to do with breaches of procedural fairness in the context of administrative law. Are any of your cases to do with the wrongful exclusion, the mistaken exclusion of evidence at trial?
That's why I was running towards the case that you'll find in the next paragraph. Paragraph 76, we go through some of these authorities. Again, I say I'm not going to take you through them in detail, but we mention amongst them the Secretary of State for the Home Department against AF. Your Lordships may well recall this case. It came up to this court and was dealing with control orders. And this is a reference to Lord Justice Sedley, who was dissenting in the Court of Appeal, but whose judgment was upheld by the House of Lords or the Supreme Court. The problem, if it be a problem, is that if you follow the footnote at 72, you get to 3718 in volume 9, but that is merely a report of the judgment of the House of Lords. It didn't include the composite appeal cases report, which also includes the Court of Appeal. So in your blue volumes, could you replace paragraph 5? Look at tab 5. And this is the House of Lords decision in AF number 3, but also in ANAE. Very familiar case, I'm sure, to all of you dealing with control orders. This is an example of the Court of Appeal dealing with a breach of the principles of justice in the court below, using the Rees and John test. And you can see this, for example, in the dissenting judgment of Lord Justice Sedley, which is in this report at page 317. This is where there was the procedural error was to move to decision without considering the evidence. So it's, again, not on our facts. It's the trying to find some principle in these cases. The issue 112 is accordingly, in my judgment, free of authority. The question for this court is whether in a case such as AF's, where the judge took the view that he could be sure that the evidence, albeit wholly undisclosed, was unanswerable, the law regards the requirement of a fair hearing as satisfied. And the answer is no. And you get over the page at paragraph 114, the reference to the celebrated dictum of Mr. Justice McGarry and John and Rees about the fallibility of judgment based on partial evidence matters so much. And to insist, I'll allow you, of course, to read to the end. I wasn't going to read it all. It's down to 115. The House of Lords judgments begin at page 336 of the report, and the decisions of the Court of Appeal begin at page 345. In the Court of Appeal, my Lord Clerk, together with Lord Justice Waller, had given the judgment with Lord Justice Sedley dissenting at paragraph 33, and you'll see that the dissent is endorsed in paragraph 36. And to like effect, you can see a reference to John and Rees at paragraph 60, and again at paragraph 73 in the judgment, the opinion of Lord Hoffman on page 357. Again, at speed, my Lord, what I'm showing you is that our cases are not all administrative cases. Yes, they all depend on their particular facts, but we say in our case, we had been deprived of the opportunity to question on the basis of this particular document, but just as importantly, deprived of the opportunity to make submissions on that basis. The authorities relied on by the respondent, there are several again. Lord, I won't deal with them in detail, save to say this, that when one looks at the cases such as Labrouche and Frey, which is in volume 7, page 2454, that again, John and Rees is featuring in the judgment of the then Master of the Rolls, Lord Newburger, at paragraph 24. So we would rely on Labrouche and Frey and see it as assisting our argument rather than undermining it, and also paragraph 38. I could spend the rest of my allotted time to go through these cases, but I hope you'll forgive me if I don't. And can I leave any further analysis to reply if needed? I mentioned earlier that we had referred to Cotton, and I note that it's incorrectly flagged. It should be at volume 9, page 3621, but you'll find them all in volume 9. So, my Lord, could I then move to deal with the end of this topic before I get to ground 2? What I said a few minutes ago is that as far as we were concerned, as far as the divisional court appears to have been concerned, the copy cable was important, and it was the main evidence to contradict the evidence being given by Mr. Roberts and Ms. Yaden. I've mentioned already, and you've seen this in the attachment to our case, the reference to broken bat and golden bullet, etc. If you look at the divisional court's judgment, this is volume 2, the divisional court's judgment we looked at earlier, begins at page 353. The analysis of improper purpose begins at paragraph 21, and it's here where you see the reference to Lord Justice Stanley Burnton's judgment in paragraph 23, and over the page, top of 360, you'll see that what he anticipated is that the court will have to decide whether or not they are genuine documents and that they are copies of what they purport to be. And then he went on to state that he did not see how the present claim could fairly or justly be determined without resolving the allegation made by the claimant, if I interpose, based on the WikiLeaks document, as to what transpired at the meeting of the 12th of May. The words I've interposed are in the judgment by Lord Justice Stanley Burnton at page 424 of the same bundle. When we get to the analysis, you will have recalled, if you've looked at the the references to the transcript, that the questioning of Mr. Roberts was extremely unfortunate. It was First of all, on the basis of neither confirm nor deny, and I asked some questions. That was resulted in a judgment in our favour that I could go on to ask questions. Then there was reference to the Official Secrets Act, and there was a discussion about that, all in the middle of the cross-examination of Mr. Roberts. We had a ruling on the Official Secrets Act, which was appealed to the Court of Appeal but not brought here. And then I started again, and the next interruption was, by the way, there's the Vienna Convention. And that was just as I was about to start again. And you'll see from the transcript that I effectively gave up at that point and said there were no more questions to Mr. Roberts. And that is the subject of some criticism by the Court of Appeal, indeed by my learned friend, that I chose not to ask more questions, particularly about his dealings, if at all, with the Secretary of State. So when you come to the substance of ground 1, paragraph 52 is at the beginning 2 lines. Mr. Fleming realistically acknowledged that our ruling as to the admissibility of the document undermined the factual premise of his first ground of challenge. In fact, I had asked them not to make a finding in light of the ruling, and you'll see that that was dealt with. And what follows is, as you go through 59 onwards, the Divisional Court is analysing the evidence and the oral evidence all without the cable. So there is, as I said earlier, nothing in the counterweight. And this becomes particularly clear when you look at the final analysis in paragraph 74 through to the end, where this is where the court deals with the end result is that the circumstances would provide an unconvincing plot for a novel. But if one goes through those paragraphs now with the cable as an admitted document likely to be accurate for the reasons we were submitting, then we say the analysis could, probably would, but could have been different. And one of the points I've mentioned already is in the note, the reference to Man Fridays is a small point. It's contradicted adamantly by Miss Yaden, contradicted not so adamantly, but contradicted by Mr. Roberts. If the cable was authentic and reliable, why on earth would that be fabricated by the political counsel whoever took the note? But if that was accepted as being an accurate note, then it cast doubts on the evidence of Mr. Roberts and Miss Yaden. We deal with makes no difference in paragraphs 8 to 9, in our argument. Unless you have questions on makes no difference, we ask you to reject the analysis in paragraphs 8 to 9 and 93 of the Court of Appeal's judgment. Lord, the third point I wanted to deal with, the first was the 2 documents, the second was the correct legal test, the third was the transcript. Lord, having thought about it in the time left to me, we've added extracts from the transcript as the appendix to our case. Could I ask you at some stage to run through the cross-examination of Mr. Roberts and indeed Ms. Yaden? And we ask you to accept that the criticisms made are unfair. Could I then, in the last 10 minutes, turn to what is in many ways as important an issue as any other in the case, and that's attribution. So we've now got to the position where, if I'm right so far, and we've had our cross-examination and we've had a conclusion on the facts, we get to attribution on the basis that the court has accepted as a fact that an improper purpose, assuming that also to be correct, so at least as far as Mr. Roberts was concerned, was to create and enforce an MPA with no fishing at all in order to undermine the Chagossians' claims to resettlement, however it's formulated. In other words, the wording that you see in the copy cable. So this means not only accepting the cable as a reliable record, but also rejecting the oral evidence to the contrary by Mr. Roberts and Miss Yaden, And any rejection of their evidence will also mean concluding that Mr. Roberts in particular, perhaps less so to Miss Yaden, but Mr. Roberts had attempted to in some way mislead the court. So that's the factual basis on which we proceed to attribution, which is very different from any of the cases that we have seen. So as we say in our case at paragraph 93D, let it be thought that this is impossible to have happened. At 93D, we refer to the long Chagos story not being free from concealed motives and hidden agendas of precisely the nature described in the WikiLeaks cable. Footnote 102 refers to the judgment of Lord Justice Laws in Bancoult number 1, which is in volume 12, page 3352. We sometimes forget about what was being done in our name with the Chagossians. Could I take you to volume 12, page 5332? It's towards the end of the volume.
Yes.
And the particular paragraphs we wanted you at some stage to look at was 1
Yes.
and 6 to 20, which begin at 5363. But the only one I wanted to read out or read to you is at paragraph 13 on page 5367. This is when there was an attempt to misrepresent the status of the Chagossians, that they were to be described as effectively itinerant workers.
These are points being made about the conduct of the FCO in the 1960s, is that
Yes.
right? I mean, what is the submission that there is a kind of continuing institutional dishonesty which must therefore have affected Mr. Roberts?
No, my lord. It's to show that it is not impossible that such activity would happen, and I'm showing you just 2 examples of where it has. And that's all. Of course, I can't connect Mr. Miliband in 2010 to his predecessor. Was it Michael Stewart? I can't remember who was Foreign Secretary. But this is what was being said, and you'll see as you go through paragraph 13 that this device was the subject of a comment, a manuscript note. You'll see it at page 5368 between C and D. There is a manuscript note by another official which comments on this minute. It refers to a certain old-fashioned reluctance to tell a whopping fib or even a little fib, depending on the number of permanent inhabitants. And you'll see, to like effect, the deceit of the United Nations is described, and I won't take you to it, by Lord Justice Sedley in Bancoult number 2, 2004, and that's at volume 13, page 5423, paragraph 6 at 5426.
I quite enjoy the remark of the Permanent Undersecretary on page 5368.
Lord, I was resisting reading it out, but it is.
Well, I think equating seagulls and women is a little...
It was awful, and to see the word "no more Man Fridays," you can see how distressing it is for the Chagossians to see it in 2009. The other one is a consistent complaint over the years has been about a possible steer with consultants. And I think only my Lord Kerr, in your dissenting judgment in 2006, mentioned the word steer, and that's at paragraph 137 and 140 at volume 13, page 678, 679. But the point I've made is the one I've just made to my Lord Sumption. But then the context is also important when we look at this attribution. Commissioner Roberts is not some lowly official. He's not some person producing some data or a fact. He is, and he was at the time, responsible for the buyout. He was the senior civil servant, and with Miss Yaden was largely responsible for the administration of the Chagos Islands. He was also, and this is fundamental to the attribution case, he was the person who was promoting the no-take MPA to the Secretary of State. So he was in an important and pivotal position. The fact that there is no other reference to this purpose, and indeed a denial in one internal document by Ms. Yaden, is, we say, unsurprising. The fact that you only find a record of it in a private conversation with US officials is, I say, unsurprising. It might be surprising to find it recorded in internal documents, particularly in light of the history that I've just shown you. In our printed case at paragraph 104, we set out the main paragraphs of the Court of Appeal judgment and summarise our case on cross-examination. Could I just add a couple of references to footnote 115, and then I'll move on to the case law. So it should be at paragraph 105, which is on page 196, and you'll see we refer to the cross-examination in footnote 115. Could you also mark up, this isn't really day 2 that was the problem, it was day 3. So it's day 3, pages 127 to 128, which is volume 2, page 973. Volume 3.
Volume 3, yeah.
Volume 3, my lord. And you can see my reaction, page at 130, internal page, and also after the ruling, which you'll find at internal page 976, no further questions for Mr. Roberts, at page 140. And also, if on day 2, could you add to the footnote 115 to look at the whole process, and you'll see Mr. Kovacs stepping up and intervening as I was asking questions, for example, at page 925. So, my lord, I won't go through all of that in the minutes now left. So, what do we have? We have 3 ways of dealing with attribution. First of all, attribution without any further evidence, and we set out the case law on which we rely in 107 to 112. And, Lord, it would, I can't go through that again in detail. We say there's no case on point that we have found. We're grateful to my Lord Sumption for the Independent Television Commission case. We should refer you to the Court of Appeal decision that we've mentioned earlier in our case, which is it's called the Carver case, the National Association of Health Stores. But this is similar to the Independent Television Commission case. It's dealing with facts, and you can find that at volume 9, page 3631. It's a Court of Appeal decision unreported, and you'll see that the Carver is being introduced in paragraph 1. The principal ground of challenge, paragraph 2, is that in each instance the minister authorised the measure in ignorance of the relevant fact that prohibition was opposed by a leading authority, Professor Ernst, and that is then dealt with as the first issue. And what knowledge does the law impute to ministers is dealt with on 3635, reference to Bushell, through to 3639, paragraph 37. And the end result is 37. You can't get around this question of imputing knowledge in this way, because the serious practical implications of the argument is, contrary to what was decided in Bushell and other cases, ministers need know nothing before reaching a decision, so long as those advising them know the facts. This is the law according to Sir Humphrey Appleby. It would covertly transmute the advisor into the decision maker, and by doing so, it would incidentally deprive the advisor of an important shield against criticism where the decision turns out to have been a mistake. Lord Justice Keane, adding a few comments of his own, at paragraph 75, you can see he's again concerned with the minister's own knowledge when looking at a relevant factor, complete ignorance. And you'll see in 72 that he's dealing with the same kind of point that Lord Justice Sedley is dealing with. Where a decision is in truth one taken personally by a minister, the normal principles of administrative law will apply, that on a challenge by way of judicial review, the court will consider whether the minister as decision maker has taken into account irrelevant considerations or failed to take into account relevant ones. And then back to the Pecco-Wallsend case. But they're not dealing precisely with what we are troubled by, which is improper purpose or motive. The same with the decision referred to by Lord Sumption this morning, which is the ITC case, at pages 315 to 316.
I don't think that anyone has got that apart from you and I.
Oh, I'm sorry, my lord. If I can just give you the references without taking anybody to it, this is whether or not a paper, including facts, a paper which was brief and compressed as one, should have been in the mind of the decision.
What's the name of the case, just for the...
Of course, the case is called the Crown against Independent Television Commission, decision of this court, 1996, EMLR 291, and the relevant pages,
Sorry,
again, 1996, EMLR 291, at pages particularly 315 to 316.
Perhaps it could be added as tab 9 into the blue folder.
Well, I can't wait to do that. It will be done. Lord, that will be, yes, tab 9. So we're not looking at Carltona. We have called it Carltona in reverse. And we've taken a simple example to try and illustrate what we're dealing with.
Why do you need attribution in this situation? I mean, this is 2005, but there is more recent Court of Appeal authority that judicial review will lie irrespective of fault if a decision maker's decision is flawed by virtue of the fact that he's simply ignorant by virtue of the incompetence or failure to act or pass on of some subordinate about some relevant fact.
But that's what I was saying.
Yes, I mean,
as well.
you're treating it as a question of attribution,
Yeah.
which is slightly different.
Yeah.
That's not attribution, that's just saying you look at the decision, it's flawed because of ignorance.
Yes.
But your case, as
you're
I
relying on
understand it, is that this is flawed not by ignorance,
Yeah.
but by the impropriety of the motive. Yeah. And can one have a vicarious impropriety of motive?
Well,
Because that depends critically on effectively the good faith characteristic of the decision maker's state of mind.
Yes.
Well, what I'm looking at is the impropriety of motive, certainly, which is revealed on this premise in the mind or heart of the main official, presenting the proposition to the minister.
Yes, and you were suggesting that that was attributed, and
Yes.
I was suggesting that...
Or it's by omission.
Judicial review isn't based on attribution, and if it isn't based on attribution, then you get Lord Sumption's position that you actually look at the decision maker on questions of bona fide.
Well, let me then give you the example, which is to try and bring this together, and why this is of general importance. The example we were looking at is a simple planning example. So the decision is taken by a local planning authority, refuses an application for development. That's the subject of a statutory appeal to the Secretary of State. The application is called in and determined directly by the Secretary of State, following a recommendation to refuse it by a planning inspector. So he's going against the planning inspector. The official assisting the Secretary of State, and perhaps presenting or summarising the argument, favours the development, perhaps because he has land nearby, which will give him a benefit. So he has an unrevealed commercial interest. Is the decision made by the Secretary of State to grant permission to develop the land challengeable on the basis of the improper purpose or ulterior motive of the official? And we say, yes, it is.
You can put it that way, but the other way of putting it is that the minister's decision is tainted because he didn't have relevant information.
Yes, well,
You don't.
I'm content with it to be either way, that he's not aware.
Either way, it's maladministration.
Exactly.
So,
Your submission, therefore, has got to be that a minister's decision may be vitiated, though his own motives are entirely proper. It may be vitiated by his ignorance of the fact that one of his advisers had a vested interest. That's got to be the submission, hasn't it?
because if you discovered his advisor had a vested interest and took that into account, but still followed the advice, it wouldn't alter the fact that his advisor had been dishonest, but it might well validate, the decision might be valid because the minister took into account that fact.
Yes, my Lord, in other words, you don't then sue for maladministration and get damages. You unravel the administrative decision. And to add it and add a bit of colour, in that example I've given you, the official is at a cocktail party at the US Embassy. And that's when it's revealed and note is taken. But Lord, we don't really mind how you get there, as long as you get there. We have two
Never
other...
mind what we do, provided you win.
Well, you're getting the hang of it.
Mr. Fleming, don't you actually have to go a bit further than that? Because, I can quite see that if an advisor suppresses some fact or misrepresents some fact in a submission to the minister, it might be relevant to say well, the minister was ignorant of the vested interest that caused these facts to be misrepresented. But it's not enough for you, surely, to say the advisor had an improper motive if you cannot actually point to something in the advice that he was giving to the minister which was, presumably for that reason, wrong.
Why? Again,
The mere
great respect.
fact that the advisor had bad reasons for giving good advice is not relevant. If you can show that it was actually bad advice because it misrepresented the facts or for whatever, the position might be different.
No,
Or it may be good enough to say that there's good reason to believe that he might have given different advice
Yes, but-
if he hadn't had the bad motive.
well, my Lord, that's what my disagreement, with great respect to your Lordship, is no, I don't need to show that he has made an error of fact in the presentation. He may have emphasised a point, he may not have emphasised a point. He may have not pressed the case in a particular way that he would have done if he was neutral. But, Lord, that's all I can say on either attribution or failing to take account. There are two other ways, and I've got already 5 minutes over. The second is I can deal with in a sentence. We deal with it in paragraphs 114 to 117 of our case. If we need to go further because of the case law I've shown you, or I need to get something from the Secretary of State, then does the burden shift by me showing that Mr. Roberts and Miss Yaden have got this improper motive? Does the burden shift then to the Secretary of State to come forward and produce his own statement saying that's all wrong? And we say there's some support for that in the 2009 decision of Mr. Justice Mitting, but we never got there in terms of presentation. We start with merely the inference. Well, can I just assume that's read and say no more? The third way is that we should, or I should, as I was the unfortunate advocate on my feet, that I should have pressed on with questions of Mr. Roberts and Miss Yaden. And this was, we touch on this in paragraph 105 of our case. And we addressed this to the Court of Appeal, and I'll give you the references without taking you to it. We thought that we may have to ask questions, and if you look at volume 14, page 6245 through to 6249, and where you see the name Beale, delete it and produce the name Plemming, you'll see that I'm struggling with what to do about questioning Mr. Roberts, but say, yes, perhaps I needed to go further. But the more I think about it, what exactly do we put to Mr. Roberts? And I've composed a couple of questions, and then I'll sit down. Mr. Roberts, we know your standing and status in the department. As we have shown, there is evidence that in your capacity as Commissioner of BIOT, you told US officials what is recorded in the cable. did you receive instructions from the Secretary of State to make those remarks, the remarks you deny making? Or putting it shortly, did you tell the Secretary of State after the meeting that you had made the remarks to the officials, the remarks you deny making? It just becomes artificial, putting it politely. What we have to show is that he was not speaking on some frolic of his own and no more. Lord, I should then be addressing my learned friend's case on ground 2, but as it's only 4 paragraphs, can I leave it to the reply?
Yep. Thank you very much indeed. Thank you, Mr. Fleming. So we now hear Mr. Kovacs, yes. We hear later on the admissibility issue.
I think, my Lord, the intention is that learned friend Mr. Kovacs will deal, responding to what I've said, and also admissibility.
So he will deal with that. Yes, exactly. That's what I meant. Yep, fine. Thank you very much. Mr. Kovacs, thank you.
Lord, can I start with seeking the court's help in the question of how I go about this task? You will have seen from our printed case that the first issue we address is what I'm going to call the respondent's notice, the admissibility of what I'm going to call the cable. And I'm quite happy to proceed in that order as per our printed case. But I'm also conscious that you have spent most of today listening to submissions about fishing rights. And so if you want me to take that first, I will. But can I add this? The points about the admissibility of the cable and the subsequent points about what is the right test and so on are largely questions of law, and it's a matter of going through the authorities. The fishing rights point, however, is essentially a question of fact, and there's only one way that I can address that, which is to take you to the evidence. And for better or for worse, there is a lot of evidence about that, and indeed I could easily spend more than 2 days taking you through it.
But you won't.
But I won't. I could give you simply a reading list and saying, well, you need to read all that, but that wouldn't be very helpful. So I'll try and strike a balance between the two. The other point, can I add in, I have prepared in order to try and speed things up and also to try and save everybody taking notes. I have prepared 2 what I've called speaking notes, which I propose to hand out to everybody. One deals with the admissibility of the cable, and the other deals with the UN Convention on the Law of the Sea Arbitration Award. And so it may be helpful if I hand those out now. Whether or not we read them now or look at them now is a different matter, but I'd quite like to hand them out now before I get any further underway.
Well, the advantage of you dealing with the factual issue, fishing rights issue, is that it follows on immediately from Mr. Fleming. And then when we turn to the admissibility issue, we get that back to back as well. But I can't say I feel that strongly about it. I don't know whether my colleagues have any feelings.
I think it's much more convenient.
Fine. I think that's where we.
Well, I'm happy to pursue that. But can I nevertheless ask for those 2 speaking notes to be handed out now?
If the usher will sort that out. Thank you.
Some of us like taking notes. We find it rivets us to what's going on.
Some of us are less enthusiastic.
I know. So belt and braces is always a good idea.
Yes. While that's being done, how I'm going to approach the evidence on fishing rights is in this way. There are essentially 3 streams of material. One is the witness statements from the respondent. 2 is the various contemporaneous documents that were exhibited, and the 3rd is what was said about it in the judgments below. And really, as part and parcel of that, there's the arbitration award, though that's in a slightly different category. What I propose to do, because I think this is going to be the clearest and quickest way of doing it, is start off with the witness statements.
Right.
And again, we have three parallel streams here, because you have three statements from Miss Yeadon, three statements from Mr. Roberts, and a further statement from John McManus, who was at the time the Director of Fisheries at Biot and who gives evidence about the fishing that was going on. And we do need to look at all of those. All of those statements are in volume 2. And can I start with the first statement of Miss Yeadon, which is volume 2, 602. And this explains the origin of the proposal for the marine protected area. At the time, Miss Yeadon was the Biot administrator.
Thanks.
She was the Biot administrator. She says at paragraph 2, she was also the official who was responsible for writing the consultation document.
Sorry, what page are you on?
602 in volume 2.
Thank you.
So, paragraph 2, she was the administrator. She confirms that she's read the statement of Mr. Roberts and agrees with that. And then at paragraph 3, she sets out the origins of the proposal. The originators of the proposal were the Pew Environmental Group, and that dated back to 2007. Then the Chagos Conservation Trust also got interested, and the matter was presented to the government in 2008 or so. And there were a number of meetings that took place, one of which was addressed by Mr. Roberts, paragraph 9, in November 2008. And then paragraph 11.
Do we have Professor Shepherd, who I remember from the previous litigation, I think, do have his initiative, which seems to have started this all off somewhere?
I don't think we do that. It was in the stuff in the courts below.
Right, okay. Yeah.
Well, it featured quite a lot in the consideration of the Rashid documents,
Yes,
didn't it?
yes.
His role in relation to the
But
feasibility study.
Perhaps not so much in relation to this.
No, it was in relation to the feasibility
in
study,
relation
is
to
my
this.
recollection.
Yes, that's right.
Yes, he's been involved at all stages of this process. And then paragraph 11 refers to a letter that Mr. Bancoult wrote in February 2009, and I mention that in part to make clear that it shows that as early as February there was general public awareness of this proposal. Then April and May further meeting.
Did that letter raise any point about fishing rights at all? I mean, forget about whether they were rights. They were, to a degree, being exercised by Chagosians, in particular, using Mauritian ships. But if one takes paragraph 11, Mr. Bancoult doesn't appear to have mentioned that, or am I wrong?
Well, he does explicitly in another document that his group issued, which I think is exhibited to her third statement, if I can turn that up. The reference is in our case. It's 662. This was a leaflet called Returning Home, which had been published by the Chagos Refugee Group, that's Mr. Bancoult's group, in March 2008. And if you see page 662, paragraph 20 of Miss Yeadon's third statement, you'll see that in that leaflet they had talked about wishing to return to the islands, but it would need to require the introduction of an economically sustainable basis based on the fishing sector and tourism, essentially. So to that extent...
Different point. What I was asking about, his response to the proposal for a conservation area, we have set out in paragraph 11 on 606, and it supports the protected area in principle subject to it allowing every Chagossian who wants to return to have a fair chance to do so. It doesn't say subject to recognition that we exercise fishing there.
Yes, my lord, jumping ahead, it may be helpful to show you at this stage his contribution to the consultation process. We have the summary of the responses in volume 3, and as has been noted, most of them have been redacted, and can I just explain, the reasons for the redactions of the names was on Data Protection Act grounds and it wasn't considered relevant. There's nothing more to it than that. Some of the names have not been redacted. If you turn up volume 3, page 1055, that's the start, and I can show you contributions by Mr. Gifford and also at the video conference that was held. So if we turn to 1161, we have Mr. Gifford's response. You'll see there's a heading towards the bottom of 1161, Chagossian groups. And you'll see a number of bullet points there. Second one, very limited fishing anyway, so limited environmental benefit from a ban. I mean, I make it clear, and I don't think this is controversial, it's not a criticism. Mr. Bancoult is not and never has been a fisherman himself. Could have significant consequences for Chagossian's resettled population, could be employed in surveillance. What effect on Chagossian community? Should not be possible to use MPA as a way of entrenching no right of abode. Inconsistent as far as concerns fishing with law of the sea, UNCLOS. So certainly Mr. Gifford, for one, is raising right back then the questions of rights under UNCLOS. And then the video conference, if we turn to 1201, you'll see that this took place on the 4th of March. Chagossian community in Mauritius, and then over the page, members of the Chagos refugee group, led by Mr. Bancoult, joined by Mr. Gifford and a number of their colleagues, participated in discussion while a large group of fellow Chagossians assembled outside, most talking done by Messrs. Bancoult and Gifford. And you'll see again a number of bullet points. It goes on for quite a while, and you'll see about 5 down, sovereignty of Mauritius also involved, and interest of other states. And then about 2/3 down that page are fishing rights which they need in their sea. I don't know if, can you see that?
Yep.
And then you see a number of other points are made. So that was their contribution. So I think my answer to your Lord Max's question is yes. Mr. Bancoult, amongst others, was indeed raising the question of fishing rights, but what I say, it wasn't being raised distinct from any question of sovereignty and distinct from being an important part of the rationale for the economic justification of a viable resettlement. No distinct point was taken about fishing rights pursuant to the 1965 undertakings by anybody. And my Lord, can I at this point mention another distinction which I don't think is, hasn't been addressed on. In the courts below, there was much argument about fishing rights of whom, and on the one hand there was discussion of fishing rights of Mauritius as a state based on the 1965 undertakings and or UNCLOS, and on the other hand there was discussion of fishing rights for Chagossians, Chagossians as traditional inhabitants of the region. Now, it's all along been our case that there simply never were, and nobody has ever recognised, Chagossian fishing rights as opposed to Mauritian fishing rights. Now, it wasn't clear in the courts below whether that was maintained, but it doesn't appear to be maintained as a distinct argument in this court. So, when we are talking about fishing rights, we are talking about the rights of the state of Mauritius and not about the Chagossians, Chagossians. If we go back to Miss Yeadon's first statement to continue with the history of the development of the MPA proposal, at 6:07 there was an important conference at the National Oceanography Centre in March 2009, and there was a direct link by hyperlink from the consultation document to the report of this conference. And that was attended by Miss Yeadon and others, and she recounts that in her review of the draft of the report, the first draft referred to Chagossian fishing rights, which she crossed out to make it clear that there weren't any. And also she said that she emphasised that the outcome of the consultation was without prejudice to the outcome of the proceedings in the ECHR. And again, can I have another diversion? Lord Sumption, I think, in the course of the morning, made an observation about it always being understood because the arbitration was underway. My lord, the arbitration was not underway. The arbitration came out of the blue by a claim form being issued by Mauritius on the 20th of December 2010. So that's after the MPA. There was no pre-action protocol or anything of the sort. So the arbitration itself postdates it.
It was a European court.
Yes, your lordship's entirely right. What was underway was two things. One, the long-standing argument about sovereignty between the UK and Mauritius. That was well underway. And two, as Lord Mance rightly observes, there was the pending case before the European Court of Human Rights, which was essentially about right of abode. So, to fit that into the context of the consultation, consultees were under no illusion that the whole MPA may never get out of the starting ground for at least two reasons. One, Mauritius was asserting sovereignty, as the consultation document made clear, and two, there was pending litigation about the right of abode before the ECHR. So consultees, if they wanted to make a point about wanting to sort out the legal landscape before any MPA was declared, they had abundant basis for making that point given on the information that they had been given themselves. So, following those developments, the Secretary of State then took the decision in the autumn of 2009 to launch the public consultation. And by that time, there had been meetings with Mauritius, which I'll come on to in due course. And then Miss Yeadon explains why she worded the consultation document in the way that she did. And, my lords, although I'm not going to read this out because, as Lord Newberger rightly observes, I haven't got the time to do so, I do rely on every single part of this because it's an important part of the history. Then at 23, Miss Yeadon categorically denies that I, or to the best of my knowledge, any other person in government, which of course would include Mr. Miliband, was influenced by any improper motive as alleged or at all. And indeed she says that she was at pains throughout to make it clear that this proposal was subject to the outcome of the litigation. And then she refers to the consultation process, and at 26 to the responses in the video conference. And if I can then turn to the first statement of Mr. Roberts, and we find that at 616. Mr. Roberts was at the time the Commissioner for Biot. He's now Governor to the Falkland Islands. And he says, 617, again, paragraph 2, clear from the outset, I say at once, both speaking for myself and on behalf of the defendant, that the decision to create the MPA was not influenced by the alleged or any improper motive.
Which paragraph is that?
That's 2. And then Mr. Roberts at 3 deals with the newspaper articles, and he says at 4 that the response of the respondent is at 2 levels. The first is neither confirm nor deny, and the second is to exhibit the contemporaneous documents, and I'll take you to those after I've gone through the witness statements. And the point that Mr. Roberts was making, and the point that I shall seek to make, is there is nothing in the contemporaneous documents which has any suggestion of the improper motive, or indeed any improper motive, in the proposal for the MPA. Then he sets out in the following paragraphs of his statement the genesis of the thinking behind the proposal and how that's consistent with the environmental policies that have been pursued by Her Majesty's government, in particular in the overseas territories, in a number of years and in a number of different ways. So this proposal on environmental grounds was entirely consistent with long-standing government policy in environmental matters. And then, can I skip forward to paragraph 13 on 624?
Yes.
By April 2009, we'd reached the point where scoping work on Biot was sufficiently clear to present the issue to the Secretary of State. I prepared a confidential note to the Secretary of State dated the 5th of May, and Mr. Plemming showed you that, and for the note it's bundle 2491. There's no suggestion in my note or in the oral presentation to ministers which followed on the 6th of May, and there was the documentation about the minister's response on the 6th of May before the lower courts. I think we haven't troubled you with it. That the establishment of a Biot marine protected area might prevent resettlement in the future. At this time, resettlement was simply not a live issue. Policy on resettlement was already settled, was not now up for review. We were aware that the creation of the marine protected area should be done, if at all, in a manner that did not affect and without prejudice to the ECHR litigation. The potential benefits were set out in the 5th of May note under the headings that Mr. Plemming showed you. Then ministers approved that work and asked for it to be continued. And then 15, between May and October, we were occupied with extensive discussions with stakeholders. I took part in some, but by no means all of these. He focused on negotiations with the government of Mauritius and the government of the United States. Key points were, respectively, a visit by him in July to Mauritius to talk to the foreign minister, and formal negotiations with them, and also the United Kingdom, United States annual political military talks in Washington in September. He refers to the July talks, and you will recall that the joint communique from the July talks was attached as an annex to the consultation document. Then he refers at 16 to the meeting on the 12th of May, and he says over the page, but the same paragraph in the middle of the page, officials have a duty to consider all angles and implications of policy proposals. I cannot speak for the drafters of the cable, but as a matter of policy, it was clear that any form of entrenchment of the marine protected area would be unacceptable to the United Kingdom and US governments on operational security grounds, and that the establishment of the MPA would have no impact on the question of resettlement. This is why it was not even raised in the note of the 5th of May. The issue at the heart of the claimant's allegation of improper motive, namely resettlement, was thus never a factor in the development of the policy on the MPA. 7th of September note we put to the US as the basis for the 2009 Paul Mill talks. Redacted copy appears, and then he refers to a number of the bullet points.
Do you have a reference for that?
I don't.
If you don't worry.
No, not at the top of my head. My juniors will let me know. I'm afraid I haven't noted that. It certainly was a document before the lower court. The other extracts from the cable which the claimant cites are matters for the drafter of the cable. All FCO staff who work on Biot are aware of the history of the territory of Mr. Greenhill's notorious references to Tarzan and Man Fridays, which Mr. Plemming kindly showed you, which is cited by the claimant's solicitor in one of his letters. Neither I nor my FCO colleagues would ever use such language with the intention of disparaging the Chagosian community. And there is more to say about that when we come to his third statement. Following extensive informal consultations from May to October, in late October we recommended the Foreign Secretary to agree to launch formal consultation, and there was a submission from Ms. Yeadon recommending that. I confirm to the best of my knowledge and belief the consultation process is carried out in good faith and with a genuine interest, engaging public opinion, ensuring that the Joscan communities, among others, are able to express a view. Consultation closed on the 5th of March. At this point, the political calendar is dominated by the impending UK election. On the 3rd of March, 30th of March, and I will show you these contemporaneous documents because they are important, but I'll get to the end of the witness statements first, made a submission to ministers recommending that although the consultation had been successfully completed, there was further work to do with stakeholders before establishing an MPA. Then redacted submission, and then there's no suggestion in this detailed advice that establishing an MPA would have any bearing on the possibility of future resettlement. On the contrary, paragraph 7 recalled that the consultation was only about how to strengthen protection of the marine environment in Bayard, expressly on the basis of the current government policy against resettlement, but without prejudice to the outcome in Strasbourg. Foreign Secretary sought additional advice, and again, we will look at these documents in due course. The Foreign Secretary subsequently confirmed that his intention was to establish a no-take MPA covering the whole of the Bayard Fisheries Conservation Management Zone. And I'll show you it in due course, but the declaration of the MPA is not anything about no-take. When we look at the accompanying press release, we'll see that it is the Minister's intention in due course to include no-take. But the proclamation itself says nothing about the content of the MPA, and it's not the proclamation that says it's a no-take zone. But we'll come to that in due course.
Can I ask you, just while it's in my mind, it's just occurred to me to ask, is it accepted that if there was a purpose of preventing resettlement, that would be an improper purpose?
You mean by Mr. Miliband?
Well,
By the Secretary of State ex officio.
well, say by Mr. Roberts. Or by whomever.
Well,
is it an improper
let's
purpose?
take it in different stages because it's a multi-part question. Let's assume improper purpose by Mr. Roberts, but not by Mr. Miliband. We say that does not touch the decision.
No, yes, I appreciate that. I'm just wondering, is it accepted that a purpose of preventing resettlement of the Chagos Islands would be an improper purpose?
Yes, because it's put forward as an environmental objective. Now, again, to be clear, as Lord Sumption has already observed, it may or may not have had consequences for resettlement, and those consequences may well have been in the minds of Mr. Roberts and or Mr. Miliband. But the fact that you were aware of a consequence for resettlement does not mean that it is your purpose for making the decision. And I hope that distinction is clear.
And my follow-up question is, if that was a purpose, and it's conceded to be an improper purpose, and there were also other purposes, environmental protection, for example, is it accepted that the existence of an improper purpose would vitiate the decision?
If it was a material factor that the decision maker took into account, then as a matter of standard public law principles, the answer must be yes.
Thank you.
Well, a material factor, one never knows quite what that means. A factor without which the decision wouldn't have been made, or is that has it got to be a factor which made a difference?
Well, the courts have generally looked at the facts of the case to get the nuances as to whether material is something that they recognise or not. Because my case is quite clear that there simply was no improper purpose at all, I'm quite happy to proceed that if the decision may well have been, I appreciate Lord Mance, when your Lordship was writing the judgment in Bancoult number 4 last year, you gave a variety of different formulations, and we can look at those in due course. And you said whichever one of those you apply, it fails, and that's very largely my approach in this case.
Well, there's probably some authority on it. And
well, there's your Lordship's as good authority as any.
Yeah. I mean, there was obviously, as I understand the history, there was already a law in place preventing resettlement. So
yes.
the impropriety presumably wouldn't be simply that you wanted to prevent resettlement. It would be the fact that this was a purpose that had not been disclosed. Is it, or am I wrong about that?
Well, it's the other side that's alleging whatever the improper motive is.
Yeah.
And I'm saying that whatever they're alleging, there wasn't one. But it's up to them. I'm not going to put their case for them.
Okay.
If they want to spell out what they say the improper motive is, that must be for them.
Okay.
The impropriety, I suppose, could, in principle, consist of doing something which would make it impossible to have a change of policy about resettlement.
Yes, and to that extent,
And that's why you emphasised that nothing prevented them from modifying or rescinding the MPA at some future stage.
Your Lordship's entirely right, and I'm grateful, but there's the other side of the coin to that is there's evidence, and it's picked up in the judgments below, which is precisely why no entrenchment would have been acceptable. And when I took you to Mr. Roberts, 626 is the first of a number of references. If we just look at 626 in the middle of the page, I cannot speak for the drafters of the cable, but as a matter of policy, it's clear that any form of entrenchment, and that was very much the focus. We have been clear all the way along that an entrenched MPA, which would have that effect, it couldn't be changed or modified. That would be something else, but that has never been what the MPA is. And there are a number of references as we go through to see this. And we have always made it clear that it can be modified or repealed.
How would you in any event have been able to entrench it, even if you'd wanted to?
Well, that's a good question. I'm not sure what the answer to that is, but we were quite clear that it wasn't going to happen.
Yep.
Yes, I think I'd got to the bottom of 626, the bullet points in the political military talks with the United States in September. 8th bullet point, 10th bullet point, nothing in the proposal affects the UK government's policy to prevent resettlement. Any proposal will be without prejudice to the current proceedings. And then, yes, I'd got beyond that. And we're on to the 30th of March. Yes. 21, 628. Although the Foreign Secretary was aware of the various political issues and risks around the establishment, he was always, I believe, motivated by the environmental objects. So that's further evidence of his state of mind. At no time did I or any officials in my directorate discuss with him or with any other minister suggestion imputed by the claimant that establishing the MPA might prevent the resettlement of by Chagostians for the simple reason that the MPA was not relevant to the question of resettlement.
If you're ever going to get back to, or if we're ever going to get back to question of purpose and what vitiates a decision, certainly in the company law context, we discussed it in a case called, Supreme Court case called Eclairs Group against Glengarry Overseas on the 2nd of December 2015 UKSC 71. And there was a difference of view, actually. The very last paragraph of the judgment, I float the question whether it's a but-for test and would probability be enough, or would the test be whether the decision would inevitably be the same, and referred by analogy to a public law test in some cases, including one of Lord Neuberger's. So, I mean, it's not entirely easy area.
Yes. No, well, your Lordship's probably picks up. I have a
where you say you can glide over it because it's all irrelevant.
Well, I need to get my sort of mental gymnastics on, because rather, as Mr. Fleming was submitting that it was unreal to expect him to do cross-examination, it's equally, if not more, unreal for me to posit an improper motive that didn't exist at all in any way, shape or form.
You say at most there was an attractive consequence.
Well, I wouldn't use the word attractive, and the word attractive doesn't feature in any of our evidence.
No.
I mean, this is the reality.
Desirable consequence, perhaps.
No, I think I would
No,
disclaim all adjectives.
Disclaim all those. Let's get on.
So that's paragraph 21 of Mr. Roberts, which again is further evidence of the state of mind of Mr. Miliband. And the same point is made in the letter written to the all-party parliamentary group. Nothing has been done to implement the MPA, and nothing that is currently contemplated would be a bar to the British government complying with any judgments of the European Court in future, or a bar to any British government choosing in future to change the policy on resettlement. Then, April to June, policy was on hold because of the change of the government. The immediate consequence, paragraph 23, was the gradual reduction in commercial fishing up to October when the last licence expired. From that point, Bayat was, I don't think it still is, the largest marine protected area. No commercial fishing activity is prohibited. Been a broad welcome generally, has of course been opposition from the expected quarters. And then 24, it's been recognised as an environmental initiative of global evidence significance, and he gives evidence about that. But then 25, we come back to fishing again. Although representatives of the international fishing industry expressed their view in the consultation process, and indeed a number of the fishing people, both Chagossians and of other nations, did, no company to which licences had been issued in the past, and of course licences were not only issued to Mauritians, they were issued to any state could apply for a licence. Mauritians just didn't pay a fee, but they weren't the only ones to get licences.
Didn't that company which sent ships up, beginning with T, Talbot, didn't it object? Did it not make representations?
No, Miss Yeadon deals with her conversation with Mr. Talbot, and we'll look at that. But no is the short answer to that. No company to which licences has been issued in the past or extant licences on April has challenged the Bayat administration's right to end the commercial fishery. Mr. Talbot never suggested that we had no right to end the commercial fishery. The owners of Mauritian registered vessels who benefited from arrangements whereby they could apply for licences free of charge similarly raised no objection in the consultation process or subsequently. This is not surprising, as these companies have opportunities to fish elsewhere. Bayat administration grants licences to vessels and their owners, not to employees or crews of those vessels, and we'll have more about that later. We have no knowledge of the nationality of those employees or crews, or of the contractual terms between them and the vessel owners or operators. We have no reason to believe that the closure of the commercial fishery in Bayat does anything of itself to reduce the total fishing effort in the Indian Ocean or out of Mauritius. There's therefore no reason why Chagossian or other employees of fishing vessels should need to suffer economic hardship as a result of the closure of the Bayat fishery. However, it's well known that fish stocks in the Indian Ocean are heavily depleted by overfishing, and it may be that employment opportunities in the fisheries sector in Mauritius are reducing. But the MPA in Bayat is a measure designed to rectify the overfishing problem, and it is not a cause of overfishing in the sector.
Employment.
And then 26 deals with what the consequences would be if the MPA were declared unlawful. The work would need to be put on hold, put at risk 2 years of work by officials and scientists and other experts, create uncertainty about the future environmental protection of the territory, would lose the benefit of private sector donations, could be offset by sale of licences. Long-term consequences would be more serious. Public-private partnership, which underlies the funding, is an experimental model designed to help achieve the ambitious global environmental targets. If the MPA were to be annulled, there would be major disincentive in the future to invest in similar forms of environmental protection. Government's always made it clear we'll respect the terms of the ECHR judgments. That was given, I think, in December 2013. The government, and that is in the bundle, the government's never argued that a marine protected area would be incompatible with resettlement. And again, you have documents in the bundle relating to the KPMG study that was published in January 2015 and the subsequent consultation. And I think the court is aware that that in itself led to a decision in November 2016 not to permit resettlement, which is itself the subject of 2 judicial review challenges. Government has never argued that a marine protected area would be incompatible with resettlement. That is the claimant's assertion. It's correct that the government has argued that resettlement is not feasible other than in a short term and on a purely subsistent basis. Government's still of this opinion, but that is independent of whether or not there's an MPA and of whether or not there is a commercial fishery. Then 28, like all FCO officials who work on buyout matters, I am acutely aware of the painful history and the grievances of members of the Chagossian community. We invest a great deal of time engaging with the Chagossian communities in the United Kingdom, in Mauritius and in the Seychelles, and enjoy good relations with many of them. I genuinely believe the establishment of the MPA in Bart is in the long-term interest of the territory and all its stakeholders, including the Chagossians, those who wish to settle and those who do not. The MPA ensures that the marine environmental capital is preserved for future generations, whatever policy decision my minister's successors choose to adopt. And there's further on that point in his third statement, but if I can skip to that now, 644. In his third statement at paragraph 11,
Yes.
there is one further matter that I wish to mention. As stated above, I do not have a detailed recollection of the 12th of May meeting to be able to state with certainty that a particular word was or was not used or by whom. However, in the context of the MPA, the term footprints was used by government, by NGOs and by scientists to refer to environmental impact. By way of illustration, I refer to the minutes of the 23rd of April 2009 between the Chagos Environmental Network and the FCO, and then he exhibits that, and you'll see the last couple of sentences. The model for an effective conservation policy framework should not involve new footprints from installations, residents and exploitation. Visiting yachts are being looked at. And indeed, the word footprint also appears in the consultation document itself. Again, same volume 2 at 531, if I could ask you to turn that up.
What page?
531.
Yes, I thought so. Right, thank you. Okay, right, thank you.
Your Lordships will see under benefits in the middle of that page, conservation benefits, 3 lines down, buyout is a place where it is possible. While recognising that it is a contentious subject, the fact is that the absence of a settled human population, the fact is that the absence of a settled human population, the strict environmental regime and the minimal footprint of the military base have enabled a high level of environmental preservation. So there is evidence that the word footprint was being used in this context. So that is
And what's this document?
That was the consultation document itself. So that was the first statements of Mr. Roberts and Miss Yeadon. I need to go to their second statements now briefly to try and keep things in order. The second statement of Mr. Roberts is 616. Sorry, not the second statement of Mr. Roberts is 640. Paragraph 4, he maintains neither confirm nor deny. And then paragraph 7 on 641, my evidence about what was said at the 12th of May meeting is given on the basis of my own recollection of it until August 2011, when the claimant served his amended grounds of claim and the further evidence on which he wished to rely, including the newspaper articles. The meeting was not one I had any particular reason to remember. My recollection of that meeting is informed by my overall understanding of UK policy on buyout and of the process by which we presented the MPA proposal to the US government, and my recollection of the points and arguments that I repeated at many meetings on the MPA within the UK government and with the US and other external interlocutors. I have, of course, read the newspaper articles. However, in all the circumstances and at this distance of time, I do not recall the 12th of May meeting with sufficient detail to be sure that any particular word or phrase was or was not used, or if so, by whom. And then he sets the context in paragraphs 8 and 9 it was at the request of the US to brief a new member of the mission, and then 10, on the UK side, policy was still evolving. The UK policy as developed was that the MPA would not be entrenched, and again it's the word entrenched that's important, would not be entrenched in any way in advance of the decision of the European Court of Human Rights in the Chagos Islanders case. I would have had no reason to say at the meeting of the 12th of May anything to the effect that the MPA was motivated by a desire to prevent resettlement. That was not the UK position at the time, and certainly not at the time that the Secretary of State took the decision on the 31st of March. By 2009, it was already UK policy that subject to the outcome of the Chagos Islanders case, there would be no resettlement. Resettlement was simply not a factor in the decision to create the MPA, save in the negative sense that the MPA was expressly without prejudice to the outcome of the Chagos Islanders case. This policy predated and was unconnected with the MPA. There is no UK document which suggests otherwise, as the documents illustrated below suggest. And he then sets out a number of those. And I won't take you to any of those now, and I won't take you to all of those, but I'll take you to a number of them. There's one further matter I missed to mention, and I've covered with that. And then Miss Yeadon's second statement is at 636. And she confirms what Mr. Roberts has said. There's one further document on this. Mr. Roberts explained why no note was taken of the meeting. It was because, in accordance with FCO guidelines, no decision was made at the meeting, and there was therefore no requirement. And the guidelines are exhibited at 648, 649, and it's paragraph D, recording decisions on 649. So we did directly address in our evidence why there was no note on our side of that meeting. I then come to the third statements of Mr. Roberts and Miss Yeadon, and if I can do Miss Yeadon first, that starts at 651. And this is addressed to the fishing rights question. I can pick it up at 5 on 654. By the time I started engaging in discussions with representatives of the Pew Environmental Group in April 2008 on the possibility of creating an MPA and carrying out informal scoping work, I was aware of the existence of the discussions in Lancaster House in September 1965. And those have been in the public domain since 1965, because the Mauritian side have made it quite clear. So there was nothing secret about the content of the 1965 undertakings.
So where do we find these Lancaster House?
I'll come to those in due course.
Yes.
They are in the bundle in a number of places.
Right.
And when you say that they were in the public domain, I mean, they had been published by the FCO or by the Mauritian government?
I think by the Mauritian government.
So they were available in print form?
I think I'm pretty much saying yes. There were a number of discussions in the Mauritian Parliament about the content of those things.
Yes,
so
they're
it was
referred to
discussed
in
in
the
the Mauritian
evidence.
Parliament. Sorry?
They're referred to in the evidence, and they were presumably available publicly in the Mauritian equivalent of Hansard.
Yes. I'll give you the references in due course, but the other side have put in a number of documents because the Mauritian ministers were questioned about why they had made these undertakings, or accepted them, rather. I was aware of the undertakings and the understandings reached in connection, recorded in paragraph 22.6 of the minutes of the meeting regarding fishing rights. I was also aware that Mauritian flag vessels were able to fish in Biot without paying a licence fee. I was mindful that Mauritius fishing rights, in inverted commas, under the 1965 undertakings was something that would need to be looked into if the MPA proposal was developed any further. We flagged up the issue of Mauritius and onshore fishing with Pew in April 2008. As recorded in my note of the meeting, we explained that Mauritius did have some rights but not exercised them recently. This was a loophole that would need to be looked into. Another issue we flagged was Mauritius' claim to the islands. We also explained a second problem was that Chagossians wanted a fishing industry, that any comment or movement on the Pew ideas would need to await judgment on the Bancoult 2 case.
But that appears to acknowledge that the issue of Mauritian fishing rights was a separate issue from the issue of Mauritian sovereignty.
Well, I'm going to take you through the history. It was something that was specifically looked into by Miss Yeadon and Mr. Roberts, and that led them to the conclusion that they reached. But yes.
What's Pew?
Pew's the Pew Environmental Group. They came up with the proposal for the...
They are a powerful United States environmental lobby.
Well, again, I
So
say nothing about powerful. They're a well-known and...
Well, maybe they're less powerful now than they were.
Right.
Well, they're environmental anyway.
They're environmental.
And they're US.
And they're US, yes. You're quite right. Can I continue then at paragraph 8 of Miss Yeadon 3? The term fishing rights used in the record of the 1965 Lancaster House discussions was used by me and others working in the Biot administration. In my mind, this term simply referred to the fact that Mauritian-flagged vessels obtained free licenses to fish in Biot waters. I was aware that the Lancaster House discussions and the understandings reached with representatives of the Colonial Legislative Assembly at that time did not constitute a treaty, and therefore could not see how those rights could be legally enforceable. Indeed, I could not see how the understanding on fishing rights and other facilities could legally oblige the UK to allow Mauritius to fish in Biot waters, given the nature of its terms, such as the fact that the understanding was only insofar as practical. Furthermore, I was never in any doubt that any deal done at Lancaster House was for the government of Mauritius and not for the Chagossians. Throughout my tenure as Biot administrator, my belief was that the Chagossians as such had no fishing rights in Biot waters, whether as a result of the 1965 understandings on fishing rights between representatives of the Colony of Mauritius and Her Majesty's government, or based on traditional fishing rights carried out by resident Chagossians before they left the islands. And then position of Mauritius is above paragraph 9. I considered Mauritian fishing rights under the 1965 understanding, which had in practice taken the form of free licenses for Mauritian-flagged vessels to fish in Biot waters, to be an undertaking of a political, not legal nature. Fishing rights had been one of the agenda items tabled at the UK-Mauritius bilateral discussions in 14 January 2009. We'll look at that in due course. Mauritius was seeking a sharing of fisheries resources. We understand this to be linked to Mauritius' claim to sovereignty, for granting fishing licenses is recognised as the right of the territorial state. If the UK acceded to such a proposal, it would be, and would be seen to be by Mauritius to be, an acknowledgement of Mauritian sovereignty. I recalled that a member of the Mauritian delegation said that Mauritius' lack of interest in Mauritius-flagged vessels taking up licenses and continuing its involvement in the British Mauritian Fisheries Commission was because it was considered that those activities impacted negatively on Mauritius' position on sovereignty. I understood this to mean that the Mauritian government felt that encouraging their nationals to take up free licenses to fish in Biot waters, or working with Biot and UK officials in the British Mauritian Fisheries Commission, would be acknowledging the UK's sovereignty. The contents of this meeting and the events leading up to it described in Mr. Roberts' third statement. Thus, I was alive to the question of Mauritian fishing rights during the informal consultation process which started in May 2009. I considered it to be a bilateral political issue between the UK and Mauritius, not a legal one. It was potentially an issue to be addressed with Mauritius when we discussed the MPA proposal with them, as we plan to do at the second round of bilateral discussions scheduled to take place in July. In early July, as part of the preparations for the second round of bilateral discussions, I asked MRAG, and MRAG was a company which provided technical expertise in the physical administration of the Biot fishery zone. So it's not part of HM government, but they were the ones, not on the ground, but in the boat, if you see what I mean, and they were the ones keeping the record of the licenses and so on and so forth. I asked MRAG for a full history of fishing in Biot by Mauritian vessels. MRAG is a consultancy firm. It had since 1991 contracted with the Biot administration to run the Biot fisheries because we did not have the capacity or the experience in-house. I produced MRAG's email response, which she does. The summary set out the numbers of inshore and per sen net licenses issued. At the time, Biot issued 3 types of commercial fishing licence: inshore licences for tuna fishing by long line and licences for fishing tuna by purse seine, explained in more detail in Mr. McManus' statement. And then she goes into some of the detail on that. And then at 14, On the 21st of July, Colin Roberts and I, together with John Merton, the British High Commissioner in Port Louis, and an FCO legal advisor, attended the second round of bilateral talks with Mauritius and Biart. The MPA proposal was outlined in some detail to the Mauritian delegation, including the possibility of a complete ban on fishing in Biart waters. These discussions are detailed by Mr. Roberts in his third statement. My impression was that the Mauritian delegation's reaction to the MPA proposal was generally positive. They did not raise the subject of fishing rights under the 1965 understandings or free fishing licences for Mauritian flagged vessels in their response, which I'm sure the Mauritian delegation would have done if it had been a concern for them. Proposal for joint issuing of fishing licences was on the agenda because joint management of the fishery would be an acknowledgement of Mauritian sovereignty. So, to anticipate, there is discussion over the time all about fishing, but we have always seen this in terms of being part and parcel of the sovereignty claim as opposed to a freestanding thing. But we'll look at the documents in more detail in due course. The proposal for issuing joint issuing of fishing licences was on the agenda because joint management of the fishery would be acknowledgement of Mauritian sovereignty, so the Mauritians were keen to keep the issue live for political reasons. There was no discussion of fishing outside the subject of the joint issue of fishing licences. While I was in Mauritius for the bilateral talks in July, I was also interested to speak to Alan Talbot, and he's the man with the boats, of the Talbot Fishing Company. The Talbot Fishing Company owned and operated fishing vessels which had fished in Biart inshore, i.e. not tuna, fishery on and off for some years. So I wanted to hear his views on the possible MPA and how it might affect the company. As indicated above, the company was the only Mauritian company to take up an inshore fishing licence in 2006 and 2007 with its Madagascar flagged vessel, and owned one of the two vessels which had by July 2009 been issued with an inshore fishery licence for 2009 with its Comoros flagged vessel. And Christophe Talbot, Mr. Talbot's cousin, ran Mecfish Limited, which operated the other Mauritian flagged vessel, which had been issued with a free inshore fishery licence earlier in 2009. Mr. Talbot's first remarks was that it would be disastrous, and I think that's what Mr. Fleming was referring to this morning. It would be disastrous. Further detail about the involvement of the Talbot family in inshore fishing is contained in Mr. McManus' statement. He did not explain what he meant, and I didn't ask because he immediately began suggesting ways that he could work with an MPA, e.g. converting his boats into vessels that could carry tourists over any ecotourism resort that might come about, or equipping the vessels to assist the scientific research. So to answer Lord Mount's question, that is what Mr. Talbot had to say about the end of commercial fishing in Biart. Further consideration of the fishing point in the consultation. Mauritian historical fishing rights were raised once again in the workshop, and that's the NOC workshop. I attended the workshop in August, a copy of the third draft of the report, and she explains how she deleted the reference to Chagossian fishing rights. Then 18 and onward deals with the drafting of the consultation document. By the time I started drafting the MPA consultation document in the autumn, task which I was responsible, we were satisfied that we had no legal obligation that would preclude a no-take MPA. There was merely the arrangement for free licences for Mauritian flagged vessels. Also, in practice, the uptake of licences by Mauritian flagged vessels was very low, and Mauritius' concerns regarding fishing in Biart waters centred on their sovereignty claim, not on any claim to fish in Biart waters stemming from the 1965 understanding or free licences for Mauritius flagged vessels. The understandings are part of the background that informs my judgment as to what should go into the consultation document. And then she says she was trying to keep it concise and simple, following the guidance. Uppermost in my mind at the time was that any MPA, and therefore any MPA consultation, should be without prejudice to the outcome of the Chagos Islanders case in the ECHR. Although I did not consider that the Chagossians had any existing fishing rights under the 1965 understandings or on any other basis, I was conscious that if the Chagossians were successful in their return to the islands, they would likely need to introduce a fishing industry to have any chance of an economically sustainable settlement. And then she refers to the leaflet that I mentioned earlier. And then after quoting that, she says the last two lines of that paragraph 20, the MPA would not be and still is not a bar to their return and settlement. The MPA can be modified or repealed, and that has always been the position. I was also concerned about the interests of foreign states other than Mauritius.
But could I ask you a very elementary question? In the expression no-take MPA, what does no-take mean?
It is shorthand for saying no commercial fishing
No
licenses.
fishing.
As we'll see from, I think, Mr. McManus's statement, there is still some fishing that's allowed, in particular recreational fishing by yachtsmen and fishing effectively from the side of the shore on the bay.
The whole idea of a no-take MPA, it was no commercial fishing.
No commercial fishing, yes. It doesn't mean no fishing whatsoever. So, I mean, there would be a question as to what subsistence fishing did or did not say, but no take means commercial. At 21, she says she refers to Article 62.3 of the UN Convention on the Law of the Sea, which requires the coastal state to take into account the interests of states whose nationals have habitually fished in the zone. And then she refers to, at the forefront of my mind, were the big companies with vessels flagged to Spain, France, Thailand, Japan and Taiwan, who had fished for tuna in the Biot FCMZ, which I think is Fisheries and Conservation Maritime Zone, which is equivalent to the 200-mile EEZ in what it covers. It was mostly vessels flagged to these states that applied for licenses for purse seine and long line fishing in the Biot FCMZ. I was not thinking about Mauritius or Chagosians in this context because I've already said the Chagosians had no fishing rights and Mauritius flagged vessels had not applied for purse seine licenses for tuna fishing since 1999 and had never applied for long line licenses for tuna fishing, and applications for free and shore fishing licenses had fallen to low levels. Then she says she also identified the US as an interested party, did the impact assessment, and then at 24 she was also concerned to reassure the Mauritians that the creation of the MPA would have no impact on their claim on sovereignty. And then at 25, I did not include any reference to fishing rights as referred to in the 1965 understandings or the issue of free licenses to Mauritian flagged vessels, because of our conclusion that the undertaking as to Mauritian fishing rights under the 1965 understandings was of a political, not legal nature. Mauritius had not raised it as an impediment to a no-take MPA in our previous consultations with them, and the impact of a no-take MPA on the free licensing arrangements would be very small because of the low take-up of licenses by Mauritian flagged vessels. I also note that the consultation document included a link to the NOC workshop. Then she refers to the...
Well, on that subject, I mean, I've been looking ahead at Mr. McManus, so you're going to take us to him? Yeah. You are, yes, right.
Yeah.
Good. Yeah.
At 26, although I understand the claimant's case on fishing rights point to be that the consultation was flawed because the consultation document did not make reference to Mauritian/Chagosian fishing rights or to the possibility that such rights might exist, I would add that none of the responses received during the public consultation caused me to alter my views or to consider amending the consultation document. Public consultation gave things, and she sets out then how the responses were done, and they were summarised by Ms. Stevenson. And then at 30, in the dealings between Mauritius and the UK during the public consultation period, Mauritius never raised the 1965 understanding on fishing rights or the issue of free licensing of Mauritian flagged vessels. As far as I was concerned at the time, this was entirely consistent with the Mauritian stance linking management of resources and the joint issue of fishing licenses in Biot waters with sovereignty. This is confirmed in my briefing of the 30th of March. There's no reference to fishing rights because quite simply Mauritius never raised them, and my belief was that Mauritius did not have any legally enforceable fishing rights stemming from the 1965 undertakings. I go on to say in the submission, we do not need Mauritius agreement to declare an MPA. This sentence was included in the briefing in the context of sovereignty, i.e. we don't need Mauritian agreement because Biot is sovereign UK territory. And that brings us to Mr. Roberts, number 3 at 750. Lord, I am conscious that time is limited and I am taking a long time on this, but I do think it is essential that the court is fully seized of the detail on all of this.
Is it just relevant just to interpose here, looking at Mr. McManus on 677, paragraph 22? it appears that no purse seine fishing had been undertaken by a Mauritian flagged vessel after 1999, and that no Mauritius flagged vessel had ever fished using the long line method, which is the one which we heard earlier today was the method Chagossian fishermen like to use. Is that right? Is that the same as the long line method?
I think it is the same as
But there's no reference to the hook and line method otherwise in Mr. McManus. So unless he's missing something out, he's presumably covering it as part of the long line method, but you might find out.
I wonder if paragraph 19 talks about inshore fishing carried out by vessels from Mauritius, targeting particular fish like snapper and grouper. I wondered if paragraph 22 perhaps was just concerned with the tuna fishery. No doubt you can look into it.
If it helps, it is paragraph 19 that we're concerned.
Ah.
What's a demersal species?
Go across along the bottom of the ocean.
Yeah, it is explained so well.
Well, don't worry, I just thought there was a bit of a...
It is 4 o'clock. I appreciate it's difficult because there's so much material. It's difficult for you to decide what to take us through and what not to take us through. But it may be a convenient moment now to adjourn while you take a view as to where you've got to.
Yes. I think
if you find that you decide that really in the time available you're not going to be able to take us through everything that's essential, then one course would be to provide us with something in writing. Obviously, we don't want to read more than we need to, but equally, we don't want not to read something we should.
Well, can I put it this way?
You've provided us, I see, with a speaking note. We haven't really had a chance.
I have. You haven't had a chance to look at that.
Does that have references to the material?
Yes, it does.
It does.
You want us to?
Yeah,
If we were to read all the documents referred to in the speaking note, we would have looked at all the documents you want us to look at.
Yes. The only thing that I needed to add, which is why I've been doing it this afternoon, is in light of what Mr. Fleming said this morning, to make sure you get all the witness statements. But in terms of the contemporaneous documents, they're all referenced either in our printed case or in the... I may go through in particular, because there's a flurry of submissions and emails in the 31st and in the days up to the decision, and I may take you through those so that you get them in the correct order and see the thinking, which all goes to the attribution point. But other than that, they're all referenced.
Very well. Well, you better sort of take a view as to how much time you've got and what you think we should be taken to, given that we've got this very useful speaking note. We'll resume again tomorrow.
Yes, and can I flag up also this? One of the two speaking notes is about the arbitration award, and I'll have something to say about that tomorrow. But that is really a reading guide, and I shouldn't need to take up any time on that. The other speaking note on the Vienna Convention is important. Now, to what extent you want me to deal with that orally, I'm entirely in your Lordship's hands, but there are a lot of references in the speaking note that you may want to have a quick look through it and see how much time we want to spend tomorrow on that.
Well, as we haven't had a chance to look at it yet.
No, that's why I mention it now, just as a warning.
Very well. Well, we'll see where we go tomorrow morning when we'll meet again at 10:30. Thank you very much. Court's now adjourned. 10:30 tomorrow.